In 2008, our economy suffered one of the most significant financial crises in history. In the midst of the crisis, and in response to a fear that some financial firms' failures could cause severe harm to the overall economy, the federal government provided extraordinary taxpayer-funded assistance in order to prevent certain financial firms' failures. In the ensuing years, experts from the financial, regulatory, legal, and academic communities examined how best to prevent another similar crisis from occurring and to eliminate the possibility of using taxpayer monies to bail out failing firms. The Judiciary Committee has advanced the review of this issue with the aim of crafting a solution that will better equip our bankruptcy laws to resolve failing firms while also encouraging greater private counterparty diligence in order to reduce the likelihood of another financial crisis. This responded to the provisions of the Dodd-Frank Wall Street Reform and Consumer Protection Act that called for an examination of how to improve the bankruptcy code in this area. Last Congress, after 3 hearings, the Judiciary Committee favorably reported the Financial Institution Bankruptcy Act, legislation that improved the bankruptcy code to better facilitate a resolution of a financial firm. That legislation was the culmination of a bipartisan process that solicited and incorporated the views of a wide range of leading experts and relevant regulators. The bill ultimately passed the House by a voice vote under suspension of the rules. This Congress, Representative Trott reintroduced the Financial Institution Bankruptcy Act as H.R. 2947. Following its introduction, the Subcommittee on Regulatory Reform, Commercial and Antitrust Law conducted a hearing on the bill. The hearing witnesses all supported the legislation while providing recommendations for further refinements to the bill. Those recommendations were incorporated, and the Judiciary Committee approved the legislation by a unanimous vote of 25-0. The bill under consideration today is the product of a careful, deliberate, and thorough process and reflects a diverse range of views from a variety of interested parties. The Financial Institution Bankruptcy Act makes several improvements to the bankruptcy code in order to enhance the prospect of an efficient resolution of a financial firm through the bankruptcy process. The bill allows for a speedy transfer of the operating assets of a financial firm over the course of a weekend. This quick transfer allows the financial firm to continue to operate in the normal course, which preserves the value of the enterprise for the creditors of the bankruptcy without a significant impact on the firm's employees, suppliers, and customers. The bill also requires expedited judicial review by a bankruptcy judge, randomly from a pool of judges designated in advance and selected by the Chief Justice for their experience, expertise, and willingness to preside over these complex cases. Furthermore, the legislation provides for key regulatory input throughout the process. The Financial Institution Bankruptcy Act is a bipartisan, balanced approach that increases transparency and predictability in the resolution of a financial firm. Furthermore, it ensures that shareholders and creditors, not taxpayers, bear the losses related to the failure of a financial company. I am pleased that Ranking Member Conyers is a lead sponsor of this important legislation and want to thank him and his staff for their efforts in developing this bill. I would also like to thank Representative Trott for introducing this important legislation and Chairman Marino of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, who is one of the original sponsors of the bill and helped usher the bill through the Judiciary Committee. I also want to commend my colleague from Georgia, who is also involved in this work and who is the ranking member of that same subcommittee. I urge my colleagues to vote in favor of this important legislation and reserve the balance of my time.